Okay, our guest of honor, our next speaker, is Attorney Barry Feinstein. So medical malpractice is uncommon, but often devastating to patients. And we as doctors all fear it and sometimes feel threatened by its possibility. We consider it as, but I think we should consider it as one of the many forces that pushes us to be better, safer, and more conscious of the mighty power that we wield in carrying out our responsibilities in medicine. Today, Attorney Feinstein will describe for us a collaborative approach that can improve patient care and keep us dedicated to the highest quality. Barry Feinstein has over 25 years of experience handling a broad range of legal matters for Boston residents, including victims of personal injury accidents. He received his undergraduate degree from Northeastern and received his law degree from New England School of Law. He's licensed to practice in the Commonwealth of Massachusetts, the U.S. District Court of Massachusetts, and the U.S. Supreme Court. Attorney Feinstein is a member of the Massachusetts Bar Association, the American Bar Association, the American Association for Justice, and the Massachusetts Academy of Trial Attorneys. He's also the past president of the Peabody Bar Association, and as a Boston personal injury attorney, Mr. Feinstein has dedicated over 2 decades of his career to providing legal counsel to victims of accidents, negligence, misconduct, including matters arising from motor vehicle accidents, nursing home negligence, medical malpractice, sexual harassment, workers' comp, and more. Barry, thank you for agreeing to join us today. We look forward to hearing your perspective.
Thanks, man.
Thank you. So we can advance the slides with this little green.
I want to thank you for the fine introduction, Matt. I want to thank my very good friend, Dr. Bradbury, for inviting me. Good morning, ladies and gentlemen, esteemed members of the medical profession. I'm honored to be here today, standing not in a courtroom, but in a space that represents the pinnacle of healing and the vanguard of human care. It's a real breath of fresh air. Now I'll begin with a little story that might sound all too familiar to you. It's about a surgeon and an attorney, 2 professions that often circle each other like co-stars on a dance floor. The surgeon, let's call him Dr. Stillwell, once bumped into an attorney, let's call him Mr. Advocate, at a community function. They hit it off discussing various topics. Mr. Advocate mentioned he was a personal injury attorney. At that moment, you could almost hear the screeching halt to the conversation. It was like a scalpel grazes an unexpected artery. Dr. Stillwell's smile faded ever so slightly as he asked, "So you're the kind who sues folks like me?" Mr. Advocate, with a twinkle in his eye, responded, "Only on weekdays, doctor. On weekends, I prefer golf. Less contentious and the outfits more colorful." The humorous jab diffused the situation, and they ended up spending the afternoon discussing the intricacies of their 2 respective professions and how, surprisingly, how much in common they both had. After all, they seek to mend what has been broken, be it bones or lives that are turned upside down by unforeseen injuries. So why start with this antidote? Because it highlights a reality we often forget, that as much as attorneys and doctors seem to be on opposing ends, we share a common dedication to serve the interest of the patient, or in legal parlance, the client. I am here not as an adversary, but an ally. I am here because I believe that when the law and medicine collaborate, the beneficiary is first and foremost the patient. I am here because each malpractice case that we see in the courtrooms is more than a file. It's more than a claim. It's a person whose life has been intersected with a moment of vulnerability and who deserves the best from both of our worlds. Let's consider for a moment how intertwined our roles are. Every action taken in an operating room or a clinic can have legal implications. And conversely, every statute or court decision can impact how medicine is practiced. Our common patient is society itself, with you healing its physical wounds and with us healing the civil wounds. When these 2 noble professions sync harmoniously, outcomes can improve dramatically. Errors can decrease, standards of care can rise, and patient safety can become a reality that is lived and breathed rather than an ideal it is strived for. In Massachusetts, as in the case elsewhere, medical practitioners and personal injury attorneys operate within a complex web of interdependencies. A statute or a precedent set in a courtroom in Boston could redefine standard procedures in Springfield. Conversely, a single innovative surgical technique perfected in Worcester could set new legal benchmarks for what is considered an acceptable standard of care. Today, I urge us to look beyond the myths and misconceptions, beyond the defensive and somewhat contentious nature of our interactions, and consider a new paradigm, a partnership. This partnership does not seek to eliminate accountability or lessen excellence, but strives to elevate patient care and safety to the forefront of our collective concerns. Imagine a world where the feedback loop between our professions is one of proactive dialogue rather than reactive defense, where the first thought isn't litigation but collaboration. And that, my distinguished colleagues, is where our journey today begins. With that, let me transition into a concept that is quite possibly the most critical intersection of our professions: medical malpractice. It's a term that brings a chill to this room, but it's also a term we must demystify and understand collectively for the greater good of the patients we serve. Let's delve into what medical malpractice truly means and how together we can reduce its incidence, ensuring the highest quality of care for all. To define medical malpractice, let's grapple with the term that tends to send shivers down the spine of the healthcare community. It's a term that conjures images of courtrooms, judges, legal battles that no doctor ever wishes to be part of. However, understanding what constitutes medical malpractice is the first step in preventing it. In the Commonwealth of Massachusetts, medical malpractice occurs when a healthcare provider, be it a doctor, nurse, therapist, or licensed practitioner, does not meet the established standard of care when treating a patient, and this deviation results in a harm to the patient. Essentially, it's when the level of care you as a medical professional provide falls below what is reasonably expected of you, and this causes injury or illness to your patient. Now, what exactly is the standard of care? It's a legal concept that refers to the degree of care and skill that the average qualified healthcare provider would provide under similar circumstances. It evolves over time, informed by technological advances and changes in medical practice, and yes, judicial rulings. Consider the case from a few years back in Boston where a radiologist missed a tumor on a patient's MRI scan. The tumor was regretfully malignant when untreated for a considerable period, and in this tragic event, the physician's failure to detect an anomaly that a competent radiologist would have noticed was determined to be a breach of standard of care. Another example which still reverberates through the corridors of medical institutions is the case of a Worcester surgeon who operated on the wrong side of a patient's brain. In 1995, a neurosurgeon at the Beth Israel Deaconess Medical Center in Boston operated on the wrong side of a brain. The patient, a 75-year-old woman, was supposed to have a craniotomy on the right side to remove a blood clot. However, the surgeon mistakenly operated on the left side. The patient's family filed a medical malpractice claim, and the case was settled out of court for an undisclosed amount. The case gained significant attention and led to an increased focus on preventing wrong site surgeries. It contributed to the development of the Universal Protocol, a set of guidelines designed to prevent wrong site, wrong procedure, and wrong person surgeries. The Universal Protocol was adopted by the Joint Commission, an organization that accredits healthcare organizations in the United States, in 2004. This error, as blatant as it seems, occurred despite multiple checks. There's no question that such an act constituted medical malpractice. In this instance, the system that should have protected the patient from such a grievous error failed, reflecting a dire need for improved procedural safeguards. But it's not just these clear-cut cases. Malpractice can also manifest itself in more insidious ways, such as a failure to diagnose or delayed diagnose. For example, a patient who visits a clinic in Springfield complaining of a persistent cough or shortness of breath. If the treating physician dismisses this as a common cold, despite the patient's history of smoking, and it later turns out to be lung cancer, this might cause to be a case of medical malpractice due to misdiagnosis, delayed diagnosis, which impeded timely treatment. Likewise, malpractice isn't always about what is done incorrectly, but sometimes about what wasn't done at all. Failure to treat, failure to test, failure to monitor are equally significant. To illustrate, if a patient in a Cambridge hospital's intensive care unit isn't monitored closely for signs of infection, and as a result sepsis develops and leads to complications, the medical staff might be liable for medical malpractice for failing to monitor the patient. In each of these scenarios, the key ingredients of medical malpractice are present: a duty of care owed to the patient, a breach of duty by the healthcare provider, a causal connection between the breach and harm to the patient, and actual damages resulting from the harm. Now let me clarify, Massachusetts, like many other states, practices under the concept of modified comparative negligence. And what that means, that if a patient contributes to their own injury, the compensation can be reduced proportionately. If a patient in Lowell, for instance, does not follow the prescribed treatment plan and exacerbates their condition, this could reduce liability of the healthcare provider under the law. The complexity of medical malpractice suits necessitates a thorough understanding of not only medical expertise, but also legal acumen. Your actions and decisions in the course of patient care can have rippling effects through the lives of those you treat and through your own professional journey. It is this very complexity that underscores the need for us, attorneys and doctors alike, to work in concert. A deeper mutual understanding can lead to a healthcare environment where focus shifts from assigning blame to preventing harm, ensuring that the duty of care is not just a legal obligation, but a sacred trust upheld at every stage of patient interaction. With the stringent nature of laws in Massachusetts, the path of minimizing malpractice risk is clear. It is incumbent upon healthcare providers to remain vigilant and educated about the evolving standards of care and to proactively seek to meet and exceed them. Your duty exceeds beyond the patients you see to the professional commitment you uphold. In our next segment, we'll delve into the practical strategies that you as a medical professional can employ to significantly reduce the risk of malpractice. Documentation, communication with patients, and strict adherence to proven procedures are not merely good practice. They form the bedrock of patient safety and medical excellence. Minimizing malpractice risk, it's critical concern for all in the medical field. I want to discuss several actionable steps that can have a profound impact on daily practice and, more importantly, on patient safety. First and foremost, maintaining comprehensive patient records is not just good medicine, it's your best defense against a malpractice suit. Now, I know what you're thinking, paperwork. It's the bane of your existence. But let's consider this. Thorough documentation can be the deciding factor between vindication and liability. Imagine patients' charts as the black box of healthcare. They should tell the story of the patient's journey through your care without missing any chapters. A study showed that improper documentation accounts for over a quarter of all medical malpractice claims. Here's a straightforward mantra. If it wasn't documented, it didn't happen. Record everything relevant: medical history, tests sorted, results reviewed, treatment options discussed, and decisions made, including who was involved in the decision-making process. And in the digital age, make sure your electronic health records systems are diligently updated. The beauty and the curse of EHRs lies in the detailed audit trails. Every entry, amendment, and omission is logged with a timestamp. So if you make an error in the records, correct it promptly, but never alter historical data in a way that could be perceived as deceptive. Moving on to communication. There's an old joke. What do you call a doctor who graduated at the bottom of his class? A doctor. While it gets a few chuckles, it's also a subtle reminder that your credentials don't always speak to your ability to effectively communicate. Miscommunication is a primary contributor to patient harm and subsequently to malpractice litigation. Communication, however, is a two-way street. It's not just about imparting information, but ensuring comprehension. Invest in your communication skills. Simple techniques like teach back. When you ask a patient to repeat back to you what you've explained, That can help ascertain understanding. Provide clear and written instructions for medication and care plans. Avoid medical jargon. Speak the patient's language. In Massachusetts, we've got a significant and diverse population, which means there can be language barriers. Be mindful of this, and don't hesitate to use professional interpreters rather than relying on family members or your own basic language skills. Another critical aspect is informed consent. It's a fundamental right and a critical component of patient care. Don't just get a signature on a form. Take time to discuss the risks, benefits, and alternatives of proposed treatments. It's not only ethical, it reduces malpractice risks significantly. A patient who feels they were part of the decision-making process is less likely to sue if the outcomes are not as expected. The healthcare landscape is in constant flux. New techniques, treatments, practices emerging regularly. Massachusetts, being a hub of medical innovation, offers a unique advantage to stay at the cutting edge of medicine. Take advantage of this. Attend conferences. Participate in workshops. Read the latest journals. Remember the radiologist who missed the tumor? If they'd been current with advancements in MRI technology, that might not have been the case, and it might have ended differently. Joining peer review committees can be a way to stay informed and routinely discuss challenging cases with colleagues in a highly protected environment. These committees often help identify potential system failures and solutions, fostering an atmosphere of continuous improvement rather than blame. Commit to a culture of safety within your practice or institution. Embrace practices like surgical timeouts and checklists. Remember Atul Gawande's The Checklist Manifesto. It revolutionized the way we think about preventing errors in complex situations. Massachusetts General Hospital adopted surgical checklists and saw a 50% reduction in operation-related deaths within 3 months. If a checklist can cut mortality in half, imagine what it could do to malpractice risk. Finally, proactively engage with your patients. Develop a rapport, show empathy, and make them feel valued. It's astonishing how much goodwill can be built by simply listening to your patients. Often patients who feel neglected or disrespected are the ones who pursue litigation, not always because of the outcome, but because of how they were treated along the way. Regular follow-ups, phone calls, even a patient satisfactory survey can go a long way to building trust and catching potential issues before they escalate to complaints or lawsuits. Implementing these strategies will not bulletproof you against malpractice claims, but it'll build a culture of thoroughness, communication, and continued learning that greatly diminishes risks. By adhering to these practices, not only will you fortify your defense in the unfortunate event of a malpractice claim, but you will also enhance the overall quality of care you provide. That wraps up the actionable steps you can take to minimize malpractice risks. Next, we'll delve into the legal journey that begins when a malpractice lawsuit is filed, walking through each step to give you a clearer understanding of what the process entails and how to navigate it. Understandably, the process of navigating the legal labyrinth of a malpractice lawsuit can be daunting for a doctor. It's a journey that not only delves into the intricacies of the law, but also evokes a spectrum of emotions from stress to defensiveness. To demystify that path, let's walk through the stages of a malpractice lawsuit in Massachusetts using real-life example. Through this exploration, we'll tap into the collective psyche of doctors embroiled in such circumstances. We've got the commencement of the lawsuit, the claim. Imagine the scenario. Dr. Jane, an experienced anesthesiologist in reputable Boston hospital, is informed that a former patient, Mr. Smith, is initiating a malpractice suit against her. Mr. Smith underwent routine surgery during which Dr. Jane was responsible for his anesthetic care. Unfortunately, postoperative complications arose, leading to a protracted recovery. Mr. Smith believes that an error in the anesthetic management caused his complications. In Massachusetts, the first step in a malpractice suit like Mr. Smith is the filing of a complaint. The law mandates that this action must occur within 3 years from the cause of action. In Mr. Smith's case, the clock started when he realized that his complications might be attributed to medical negligence. Dr. Jane will receive a notice along with a complaint, her first formal introduction to Mr. Smith's allegations. Shortly after, the defendant, which in this case is Dr. Jane, files a response of pleading. A tribunal is convened as per Mass General Laws, Chapter 231, Section 60B. The tribunal consists of a judge, an attorney, and a healthcare professional. The role is to evaluate an offer of proof provided by the plaintiff, Mr. Smith, to determine if there's sufficient evidence to raise a legitimate question of liability appropriate to a judicial inquiry. During this stage, Dr. Jane might feel a mix of anxiety and indignation. She knows she performed to the best of her abilities, yet the looming tribunal has a questioning every detail of the procedure in Mr. Smith's case. His attorney must prove that Dr. Jane failed to meet the accepted standard of care, and as a result, Mr. Smith suffered harm. Once the tribunal deems the claim is to hold merit, the discovery phase begins. This phase is like a high-stakes game of show and tell. Each party must share evidence, which includes medical records, internal hospital reports, and witness depositions. It's a meticulous and often exhausting process, where Dr. Jane will have to recount the minutiae of her treatment decisions under the scrutiny of Mr. Smith's legal team. The raw exposure of her medical judgment can incite unease in Dr. Jane, as she is forced to defend her competence. It's a period of vulnerability, and yet it's crucial to her defense team to gather all the facts to represent her effectively. Critical to this process are the testimonies of expert witnesses. These individuals are tasked with clarifying to the court whether the standard of care was indeed breached. Dr. Jane's side will bring forth experts to attest to her adherence to medical protocols, while Mr. Smith's team will present counter-arguments. These dueling narratives are central to shaping the jury's understanding of complex legal issues. For Dr. Jane, these testimonies can be affirming, but they can also stir doubt. She has to place her trust in these experts, hoping the defense of her actions resonates more convincingly than the prosecution's criticism. It's not uncommon for malpractice cases to never reach a courtroom. Instead, they may resolve through settlement negotiations. Dr. Jane's insurer might calculate that a settlement is more pragmatic than the unpredictability of a trial. However, Dr. Jane may struggle with this. It's a practical solution that can feel like an admission of guilt, even when it's not. Negotiations can be tense, and Dr. Jane may be relieved to avoid the emotional toll of a trial, but equally disheartened that a settlement might imply culpability to her peers and colleagues. If a settlement isn't reached, the case proceeds to trial. Dr. Jane will face a jury of her non-medical peers who will assess the complex medical evidence to deliver a verdict. Trials can last for days, weeks, or even months, each day bringing an amalgam of trepidation and resilience for Dr. Jane. Trials are public, potentially affecting Dr. Jane's reputation regardless of the outcome. She must stay composed, presenting herself as the dedicated and competent physician she is, despite the scrutiny. Ultimately, the jury must decide whether Dr. Jane reached the standard of care, and if so, the appropriate compensation for Mr. Smith. If a verdict favors Dr. Jane, she may feel vindicated, yet emotionally drained and wary of future litigation. A verdict against her can be crushing, both personally and professionally. Moreover, Massachusetts has a cap on non-economic damages, but significant and permanent damage can override this cap. Dr. Jane may find solace in this limitation or frustration if it's lifted in Mr. Smith's favor. Dissatisfaction with the trial's outcome can lead to an appeal, an additional legal proceeding, examining the trial's conduct for error. For Dr. Jane, this could either be a second chance or an extended nightmare. The saga of Mr. Smith's lawsuit is one narrative in the complex theater of medical malpractice law in Massachusetts. Throughout the ordeal, doctors like Dr. Jane often experience a gamut of emotion, from shock at the initial claim, defensiveness during discovery, cautious hope during expert testimonies, pragmatic resignation or relief at settlements, and anxious anticipation during trial and verdict delivery. At each juncture, personal injury attorneys play a pivotal role, wielding their expertise to either prosecute or defend, but always with the underpinning aim to serve justice and promote patient safety. The journey is arduous, rife with legal intricacies and emotional challenges, yet it underscores the indelible link between law and medicine, each holding the other to account, each necessary for the greater good of patient care. The courtroom, though traditionally viewed as an adversarial arena, might not seem like fertile ground for partnerships. Yet in the realm of medical malpractice, the role of personal injury attorneys extends far beyond the confines of litigation. They are in many ways allies to both patient safety and medical professionals. As a personal injury attorney, my role is multifaceted. Let's delve into what that really entails. Personal injury lawyers are often misconstrued as being solely in the business of blame and retribution. However, the thrust of our work is to advocate for patients' rights and safety. When a medical malpractice suit is in play, we are not just seeking redress for an individual's suffering, but are spotlighting areas within the healthcare system that may require attention and improvement. Allow me to paint a picture for you. When a patient walks into a lawyer's office with a potential claim, what they are essentially carrying is a story of an expectation unmet, a trust that they feel has been breached. It's my job to listen, to understand, and to evaluate the merit of that story. Unlike the depictions you might see on television, this process is meticulous and measured. There is no rush to the courthouse steps with a claim. Rather, it's a considered journey that begins with establishing the facts. The role of the personal injury lawyer is dual in nature. We are both advocate and arbiter of sorts. We advocate for our clients, seeking fair compensation for the wrongs they suffered. The compensation is not just about monetary awards. It's about affording individuals the resources they need to recover, to rehabilitate, and to reclaim their lives after an injury. Yet in seeking justice for our clients, we often find ourselves at the intersection where individual cases have the potential to instigate broader systemic improvements. Consider, for example, a case where misdiagnosis leads to a delayed treatment of a medical condition. Through the course of legal proceedings, it may come to light that the hospital had no standardized protocol for reviewing and acting upon test results. Here, a lawyer's work can transcend the individual case by advocating the changes within that medical institution, promoting the implementation of a system that could prevent future misdiagnoses. It's critical to understand that personal injury lawyers are deeply invested in the integrity of the medical malpractice system. Frivolous lawsuits serve no one. They undermine the public trust, place an undue burden on the courts, and add unnecessary stress for medical professionals. Thus, we act as gatekeepers, carefully vetting each case, seeking expert opinions, and pursuing claims only when there is compelling evidence of negligence. We operate in a world of nuance, recognizing that medicine is an art as much as it is a science. Not every unfortunate outcome is due to malpractice. Illness and healing can be unpredictable. Our task is to discern where deviation from standard of care has occurred, and whether that departure is what legally and ethically constitutes malpractice. We do this through exhaustive research by engaging medical experts and by working closely with forensic investigators. A relationship with the truth is perhaps the most critical aspect of an attorney's role. Our reputation, and indeed the entire legal process, hinges on the ability to present and argue based on facts. Truth-seeking leads to clarity and understanding, which can then inform both the legal strategy and the larger dialogue of patient safety. In a state like Massachusetts, where healthcare is the cornerstone of the economy and where medical innovation thrives, personal injury lawyers play a unique role. We are the ones who often bridge the gap between healthcare providers and their patients when things go awry. The drive for fair compensation is therefore coupled with a broader objective: to contribute to the evolution of healthcare systems that prioritize well-being. In the courtroom, it's easy to view the drama of a trial as personal injury lawyers versus doctors, a battle waged with the patient as a sort of prize. But I urge you to see it differently. It is, in reality, a complex conversation about standards, about care, and about how we as society value and protect the health and well-being of our citizens. Medical malpractice lawsuits, while they are about addressing specific grievances, also serve as a feedback loop for the medical community. They are, albeit indirectly, an avenue for continuing education. They highlight potential flaws in practice, not for the purpose of assigning blame, but to prevent recurrences of similar incidents. It is this aspect of our work that underscores our collective commitment to improving patient safety. There's a symbiotic potential here, one that flourishes with mutual respect and communication. This potential paves the way for proactive initiatives. Hospitals can learn from legal precedents to refine their practices, and lawyers can better understand the challenges faced by healthcare professionals. In closing this section, remember that as personal injury lawyers, we are not merely litigators, but we're advocates for a system where patient safety is paramount, where compensation is fair, and where medicine can continue its noble work with the confidence that the legal system is a partner, not an adversary, in the quest for a healthier society. The next step in this partnership is fostering collaboration for patient safety, which not only benefits our clients, but also strengthens the medical profession and the community it serves. I stand before you, not only as a personal injury attorney, but as an advocate for the mutual objective we all strive for, patient safety and wellness. Our roles within healthcare and legal systems often place us at the crossroads where decisions must be made, actions must be taken, and outcomes have profound impacts on our lives. Though historically seen as separate entities, the intersection of our professions has proven to be fertile ground for progress, innovation, and most importantly, patient safety. For the mutual benefit of our professions, and certainly for the patients we collectively serve, it's imperative that we join forces, leveraging our unique skills and insights to enhance the quality of care and minimize risk. Let me share with you a few compelling stories where such collaboration has made significant strides in improving safety protocols and reducing malpractice incidents, shedding light on the path we must walk together. Consider the case of a hospital in Boston where recurring incidents of medication errors were causing alarm. The issue was systemic, a combination of overburdened staff, insufficient checks and balances, and a lack of clear communication channels. After a serious error resulted in a lawsuit, hospital administrators and legal counsel convened a series of meetings not to point fingers, but to understand the root of the problem. The outcome, a redesigned process for medication administration that included double verification systems, enhanced training for nursing staff, and improved electronic records that flagged potential drug interactions. Since this collaboration, the hospital has reported a dramatic decrease in medication errors, marking a victory not only for the healthcare providers, but also for the peace of mind of the patients served. Another compelling example arose from a situation involving surgical procedures. Surgeons from various Massachusetts medical professionals and legal professionals came together in the wake of a series of malpractice claims involving postoperative infections. The collective, instead of engaging in a defensive legal battle, focused on establishing comprehensive postoperative sanitation protocols. By doing so, they addressed the risk factor head-on, resulting in a statewide reduction in postoperative infections. The legal team, which had the data on malpractice trends, worked with the medical community to identify these trends before they could cause harm, reducing the potential for future malpractice suits, and more importantly, improving patient outcome. In a more proactive example, the implementation of routine legal checkups within the medical setting has emerged from a collaboration between legal and healthcare professionals. Just as medical screenings are designed to catch health issues before they become severe, legal professionals can help identify potential legal issues that may affect a patient's health. For instance, through a partnership known as Medical Legal Partnership, legal experts stationed within a healthcare facility can assist in resolving housing disputes before they affect patients' respiratory health, or help secure disability benefits that alleviate stress and improve overall well-being. This partnership not only promotes patient health, but also reduces the circumstances that can lead to malpractice allegations. These are but a few examples of the countless others that illustrate the efficacy of collaboration between our professions. It's not about simply responding to malpractice claims, but about creating a culture where the likelihood of an incident is significantly reduced because we have addressed the underlying causes together. As we gather here today, I invite all of us to consider the possibilities that lie ahead. Imagine a system where healthcare providers are supported by legal guidance to navigate the complexities of the medical practice confidently. Picture a system where attorneys are not only seen as adversaries but as allies, working to strengthen the safety net that upholds patient well-being. This is the potential of our collaboration, a potential that transcends disciplinary boundaries and unites us in our dedication to serve a community that best serves our abilities. The road ahead is indeed a shared one, and the steps we take together can lead to a stronger healthcare system where patient safety is the cornerstone and justice is the foundation. Let us take these steps with the understanding that we are not two sides of a coin, but we're two halves of a whole, committed to ensuring the health and safety of those who we are privileged to serve. Let this dialogue continue beyond today, and let our actions reflect our shared commitment to better outcomes for all. I thank you, and ladies and gentlemen, as we draw nearer to the conclusion of my long presentation, I'd like to take a moment to recapitulate the essence of what we discussed. The import of the path we're setting out on together and the vast potential that lies in the unity of our professional endeavors. We commenced with the premise that the relationship between doctors and attorneys can and should be more collaborative than confrontational. A powerful alliance built on mutual respect and a shared commitment to patient welfare. We are not natural adversaries. We are, in fact, allies in the pursuit of a noble cause to ensure the safety and well-being of those who place their trust in our hands. We journey through the intricacies of medical malpractice, clarifying its definition, not as a weapon of blame, but as a framework for understanding where the system may fail our patients. We looked at the very human side of the medical practice, acknowledging that despite remarkable skills and dedication in this room, medicine is not infallible. Errors do occur. Yet in recognizing this, we have the opportunity to forge preventative strategies, heighten our vigilance, and continue our education, which are paramount to safeguarding against potential harm. We explored concrete strategies to minimize the risk of malpractice, emphasizing the profound impact of thorough documentation, transparent communication with patients, and a steadfast adherence to standardized procedures. These practices are not just checkboxes in routine care. They are lifelines that can significantly tilt the balance towards patient safety and trust. Understanding the legal process surrounding malpractice lawsuits was an important step in our journey. It demystified the fog of litigation. It showed us that while the path of legal resource is complex, it's navigable with the right knowledge and guidance. Here too, collaboration plays a crucial role. It allows for a bridge to be built over the gap of misunderstandings that can sometimes divide our professions. We clarified the role of personal injury lawyers, transforming the view of them from litigators to educators and patient advocates. In cases where medical malpractice system falls short, personal injury attorneys can seek justice, yes, and they also strive to be catalysts for change, highlighting areas within healthcare that can be improved in health for all. And so we arrive at our call for action, a plea for collaboration for patient safety. We shared examples that demonstrate when doctors and lawyers come together, they not only improve outcomes for individual patients, but they elevate the standards of care across the board. We've talked about the Massachusetts medical centers working hand in hand with legal experts to reduce surgical errors, or hospitals partnering with attorneys to refine medical administration. These examples aren't just stories, they're blueprints for what we can do together. Now, as we stand on the threshold of opportunity, it's time to turn our discussion into a dialogue, to move more from thought to action. And I invite each of you to step forward, not with hesitance, but with confidence that comes with knowing we share common goals. So let us open up the floor for an exchange of ideas. I encourage you to voice your opinions, share your experiences, propose concepts for how we can jointly strengthen patient care, whether it's your insights or enhancing communication in innovative ways that we can integrate legal knowledge into medical practice. Your contributions are invaluable, and I thank you very much for your attention.
Thank you very much.
Now time for questions.
So we're going to hold most of the questions until the panel, actually. So I know everybody's really eager to ask questions, but everybody will be up here at the front, and we'll be able to address all this. But thank you. That was a great outline, and you proposed an excellent vision for us as a profession.